Is there any difference? Oh, the chapter's not nice.
Yeah, we'll talk about your career, like, because they have done something really about they know their level they were my age, so I don't know if they might do depending she was really we were here there and I was like,
Publishing articles or something?
You send me, as far as like the overall style, there's a template I can send you. Somebody sent this to me who was like, all about things style. And so I took art and I the first one based on how style I if you write focus on your content.
Yeah, I do like so I prefer that stuff. I thought you meant how to go. No, I think it's Unless you like snack salad, you might still need another job. And you seem really thankful that my book plays up the whole this.
I know, yeah, we do try and get back to that.
Especially in that whole yeah, so I think you have to do it again.
Yeah, no, we can. Like, you know, again, if you're rewriting, it's a bit longer. But yeah, we do try. Yeah.
I like to say generous. Nice to meet you. Okay, thanks, Evan. Nice to meet you. And I'll send you the seminar series.
Yeah, thank you.
Trying to solve the issue. So actually, abandoning your institutional as better framework. Basically, asking for whole rewriting and reject it. Because sometimes it's just first time listed issues or in theory.
Not really. I
Hello.
still have, I mean, I'm now
Okay. You have one stop.
no, actually, just a week ago, no. I know there is some like I'm definitely the one who's reading this. No, I want to know if I want to look for you for me.
Someone's helping. Someone's.
Yeah, it's true. I have to. And then you get to work with
Okay.
I don't know where that's happened. But we're not going to anymore.
And then
I've been married.
เช่นว่ามีความเช้าเราได้จับได้จะต่อยอดคือสมัยก่อนครับสมัยก่อน
We need to have a match up.
ประมาณ5 ปีด้วยแต่ว่าช่วงไปไหนครับ
Well,
คือ
I was gonna try and do it then.
โซเชียลลีโก้เดชูมันไม่ใช่เพียวสายแต่คือเราที่ทำคือ policy มากกว่าแต่ว่าคุณคือ
This one here?
ปรัชญาเกี่ยวกับไม่ใช่สายเราเลยพอฟังสายได้มาที่ก็คิดเราแบบเราเรื่องอะไรแม้ว่าเราจะมีความที่แต่ว่ามันก็ไม่ใช่สายเราเลยใช่ก็แบบพวกนี้ต้องอ่านมามากถึงจะเข้าใจว่าตำราการพูดยากจริงจำได้ที่บอกว่าคือรัดเท้าครับคือทำตัวไม่แต่ละอย่างนะระยะคืออยู่ประมาณที่แรงรูปจะเป็นสี
Yeah, I feel really bad. That wasn't the right time. You referred in your talk to someone made about the ICT law and whether the things done to expedite trial actually still included that story. I really like to do. But yeah. Because I think one of the things I'm pursuing in the area is all of the sort of transition from live to I want to talk about that with regard to presence at trial. It's sort of a de facto driving I agree, and there obviously, there are problems. And it's even with the ICC, it's some of the language. There are so many people in common. Okay, yeah, that would be great. Yeah, because I think it's an area I think is really interesting and fruitful. So what brought you from Australia? I guess have you ever lived here but studied? Oh, that's the best year. Oh, that's great.
So I have my notes there. Oh yeah.
Where do you live? I've never been. I don't know, it's so hard. Absolutely. But it's a very hard challenge.
I know that we have to reach for. I'm not sure. I'll be sitting in Pretoria and I'm over yeah, well, you have to this work.
We both.
Yeah, I did. Yeah, thank you.
Well, we have the yeah, it is. Anyway, so thank you for the help with this. I'm sure. Thank you so much.
Really bad at this, sorry. Oh, great, bye.
Okay, good afternoon, everyone. Thanks for coming to this session. My name is Matt Gibson. I'm chairing the session Criminal Law and Punishment. I've come down with a cold on today of all days, so I will do my best to try and project my voice. If you can't hear me, you can't hear the speakers, just come a bit forward, a bit closer. The format will be as previous panels today. There'll be 3 speakers. One of our speakers isn't here today, but we have Choky, Sharon, and Lisa. We'll be speaking to us in turn, and at the end there will be time for questions. So do please keep any questions that you might have to the end, write them down, make note of them, and we'll discuss those at the end if you have any comments or queries. And without further ado, I think we'll make a start. And our first speaker is Choky Ramadhan from the University of Indonesia, who will be speaking to us to the following title: Plead Guilty Without Bargaining, Learning from China's Summary Procedure for Enacting Indonesia's Special Procedure.
Thank you. Hello, everyone. My name is Choky Ramadhan. I'm from Indonesia, and I would like to present my paper regarding title is Plead Guilty Without Bargaining, Learning from China's Summary Procedure before Enacting Indonesia's Special Procedure for Criminal Law. Here's the thing. There's a need for efficiency in Indonesian criminal justice system, As you see, there is an increasing case backlogs in Indonesia district courts. The judge handle more and more cases each year. And on the other hand, there's a limited budget for prosecuting the criminal cases. So as you can see, in 2011, prosecutor allocated only 10,000 cases to be prosecuted. However, they could prosecute around 96,000 cases. And the question was raised, where did they get the money to prosecute such criminal cases? However, in the following year, they increased the quota, the allocations, to 100,000. The consequences, the budget for prosecuting each case increased from $2,000 to $300 for prosecuting each case. And it led to corruptions because the prosecutor extort and ask money from the defendant and the lawyers to fulfill their needs, especially in budgets. And it also creates a latent regulation or informal or unregulated procedure that proceeded by the court. This term is being used by Timothy Webster in translating Chen Huihua article. The reason I compare the plea bargain with China's summary procedure, so unlike the US and UK plea bargaining, Indonesia's special procedure resembles China's summary procedure because it shortens criminal proceeding if defendant confesses guilty. However, prosecutor and defendant cannot negotiate the charge and sentence. And the judge controls the procedure and also decisions. So it's not up to prosecutor and defendant, but the judge has the authority to authorize the sentence. And also, I want to mention Alvaro Santos' article. He criticized the legal reformer who simply introduces a univocal agenda for reform without looking to local conditions in judicial reforms and anti-corruption agenda. So I think it's worth to mention. I think it's interesting to, and it is essential for stakeholders and legal scholars to examine both Indonesian and Chinese cultural values related to punishment. As you can see, Indonesia has the adat and Chinese has a Confucianism, which highly emphasize harmony within society and see criminal justice system purpose to recover the imbalance. So punishment as the last resort, and they prefer leniency if the defendant is guilty or confessed. Here's the China summary procedure. It's a criminal procedure to prosecute a pleaded defendant for all crimes under the China 2012 CPL. Meanwhile, Indonesia's special procedure is a provision, it's still in the bill, proposed provisions under Indonesia Criminal Procedure Bill for pleaded defendants whose crimes having sentences of less than 7 years. In return, defendant will get shorter trial and also lesser punishment. And here's the interesting thing. There is no specific procedure in Indonesia's special procedure. So in the first hearing, the trial, the judge process within the ordinary procedure with 3 judges led the court. And then the prosecutor read the bill of indictment, and then defendant pleads at the first hearing. And then the procedure moved to short trial or summary procedure at the second hearing, which led by 1 judge. It's a little bit confusing, the provisions drafted by the legislators. And here are the features between the China summary procedure and Indonesia special procedure. In China, summary procedure could be used for all crimes. However, Indonesia is only crimes sentenced less than 7 years imprisonment. So only specific crimes. Crimes like felony or bigger crime could not be used the special procedure. And there's an ambiguous provisions about the judge. As I said before, first hearing led by 3 judges and then moves to 1 judge at the second hearing. And in China, there's a limitation for the case that has been charged for 3 years imprisonment must be concluded within 20 days. However, it could be concluded up to 1.5 months for crimes less than 3 years imprisonment. And there's no limitations in Indonesia's special procedure. What we can learn from China, Mike McConville found that efficiency resulted by China's summary procedure. As you can see, 96% of summary procedure resolved less than 1 hour. However, it also resulted in lack of legal counsel, which brought to an increasing risk of false confessions and also unequal standing between prosecutor and defendant. And it happened in Indonesia. Before the Indonesia special procedure being enacted. For example, in 2014, Indonesia Court Monitoring Society, where I work, observing 21 trials in Jakarta, found that defendants who do not have legal counsel tended to plead guilty. As you can see, 96% of the trial that we've observed do not have a legal counsel. And most of them, the defendants, plead guilty because they do not have knowledge, they do not have capacity to make a legal defense before the court. And most of defendants are poor, so they could get legal counsel or legal assistance. And there's problem within the Indonesian legal aid system. So the government could not provide all legal assistance or legal counsel for defendants. And in Indonesia also happens what the Timothy Webster called latent regulations. For example, the ideal number of hearings within the Indonesian criminal procedure is around 4 hearings. For example, first read of bill of indictment by a prosecutor, and then cross-examination. Third hearing, prosecution, and fourth or last hearing is just decisions or verdict. However, we found 91% of the hearing happens within the Indonesian District Court, happens between 1 up to 3 times hearing. So there's a process that has been deleted, that has not implemented by the judge. And it is what Timothy Webster called latent regulations. And also there are several contradicting provisions between special procedure and the short trial or summary procedure that creates confusion and ambiguity. For example, under the short trial procedure, the prosecutor on the one hand does not have to prepare a bill of indictment. On the other hand, the prosecutor must prepare and read the bill of indictment before the defendant confesses and the judge grants special procedure. So it's kind of ambiguous. The second punishment under the short trial or summary procedure in Indonesia should be less than 3 years imprisonment. However, the special procedure, the defendant shall not be sentenced to more than 2/3 of the usual sentence for the crime. So for example, the defendant charged for 7 years imprisonment, 2/3 of 7 years must be 4.5 years. So So it's more than 3 years that limited by the Indonesia summary procedure provisions. And I understand the legislator, the drafters, draft the plea bargain provisions within hurry. The plea bargain provisions added in our bill after conducting several discussions and study visits in United States funded by the OG and United States aid. So it's kind of premature provisions that we need to discuss more, that we need to learn more from other country experience. And I recommend that in order to enact the Indonesia Special Procedure Bill, first we have to have sufficient funds to provide legal aid, and then strict time limitation that could ensure increased efficiency for defendants, like the China's summary procedure, and also a provision that makes the use of torture to gather evidence inadmissible. And last, removal of legislative barriers to leniency in punishment. And that's all I got. I would like to discuss more about your experience, your country experience about plea bargain, so I could extend, so I could research further about this issue. Thank you very much.
Thank you very much to Choky for his paper. We now turn to Sharon Walker, from the University of Ireland, Galway. And the title of her paper is Disproportionate Rise of Female Prisoners into Disproportionate Sentence.
Thanks very much. My name is Sharon Walker, and yeah, I'm from the National University of Ireland, Galway. And I'd just like to say thanks to the organisers of the conference. I've heard some really, really interesting papers today. And my paper will actually be focusing on the disproportionate increase of female prisoners in Ireland, and specifically on the gap between policy and practice, which, in my opinion, is a huge contributor to this increase. Now, of course, the numbers of committals to prison for both genders really under sentence have increased, and this can really be traced back to the economic prosperity caused by the Irish Celtic Tiger boom, when financial investment was really being invested into expansion of prison places and into crime control. So those prison places were really filled up at that time. But if we actually look at the numbers of committals under sentence, where male increases were by 120%, female increases actually increased by 400%. Now, Ireland is not a jurisdiction that's structured by sentencing guidelines like England and Wales, but our courts are expected to adhere to the principle of proportionality, and by that I mean the sentence should of course be commensurate to the gravity of the offence and the circumstances of the offender. And when we actually have a look at the type of offences being committed by females during this time, and the type of the characteristics of the female offender, we actually can see that they are kind of the same, you know. Female crime remains to this day to be mainly non-violent, mainly acquisitive. Predominantly female offences would be road traffic offences such as driving without insurance, petty theft such as shoplifting, and other social misdemeanours such as non-compliance with police, we call them the Garda Síochána, non-compliance with court orders, things like that. The characteristics of female offenders, they haven't changed really either. And female offenders tend to characterise themselves as a group as being sort of more, what would say, more mad than bad, if you like. That was, I think it was Pat Carlin that coined that phrase. But by that I mean they tend to come from backgrounds of poverty, homelessness, drug addiction, you know, just generally deprived backgrounds, you know. So by that rationale, with crimes not changing and with the female characteristics not changing that much, then I suppose one of the first questions that I was asking in this regard was really, is the disproportionate rise a cause of disproportionality in sentencing? So, and by that I mean inconsistent application of custodial sentences. So, the Criminal Justice Act 2011 requires judges to, when they're considering a custodial sentence of 12 months or less, to first consider the making of a community service order. Now, as most female committals will actually come, the vast majority will come from district court, and the vast majority will also be for a term of under 3 months. So this should have really solved a good bit of the problem, but it didn't. The Irish Penal Reform Trust actually criticised this 2011 legislation, and it actually said that the legislation doesn't go far enough to protect against the presumption against imprisonment, because what it said was that the legislation should really not just ask judges to consider the making of a community service alternative, but it should actually require the judges to give written reasons as to why they're choosing to imprison the female offender here. But, however, you would have to kind of put this into context, and in the district court, most decisions that the judge would hand down are extempore, they're unwritten, they're unrecorded, generally unaccompanied by any verbal reasoning, and if verbal reasoning is given by the judge, it's basically unheard because of the busy, chaotic scenes in the district court. Unless the judge, of course, chooses to say something funny that might make the local rag or something. But generally, those decisions, it's not possible to have written decisions. So that's just the district court really operates like a conveyor belt system. So there's an element possibly of judicial discretion. So whilst the judge still would adhere to the standard factors, taking into account the standard factors of the gravity of the offence and circumstances of the defendant, Dr. Caroline Nolan actually wrote in 2013, the Irish District Court, a social portrait. And it was based on her experience, her empirical experience of spending 8 months in the Irish district courts, where she observed that where judges do generally adhere to the standards of proportionality, they also bring their own human factors into their decision. So the presiding judge will take into account the appearance and the demeanour of the defendant, or other previous interactions between the defendant and other criminal court actors. So you still have the adherence to proportionality, but the judge's personal opinions will come into the sentence. So it's not entirely discretionary, but So some attempts were definitely made to kind of make things more consistent in terms of sentencing. And the Irish Sentencing Information System was actually a system that was set up in the 2000s. And it was basically to create a centralized record of decisions. And this, of course, it wasn't intended to be prescriptive, but rather more descriptive in nature. It's a non-exhaustive, but it's like a central repository that would give access to some judicial decisions. Unfortunately, though, lack of funding for this system meant that progressions didn't really happen very well, and developments in it could be a bit sporadic as well. So it's not really used to its full capacity, and that comes from lack of funding. The other thing, the Irish Crime Classification System, that started in 2008. Central Statistics Office and the other criminal justice agencies, the courts service, the probation service, the prison service, they used to all categorize crime that was being recorded differently. So it was really, really difficult for researchers to make comparative analysis of how crimes were being treated, how policy was filtering down, and what policy was needed, where policy was needed. And so the Irish Crime Classification System tried to synchronize all those crime categories. And it certainly has, from my point of view anyway, it certainly does make researching this area a lot easier. The second thing really that should be looked at is the insufficient use of community service alternatives, community service orders, if you like. And the United Nations rules for the treatment of women prisoners and non-custodial measures for women offenders, or the shorter version, the Bangkok Rules in 2010. That was really to address the most common problems that led to women's interaction with the criminal justice system. So the common problems really that were identified were really the sort of things that identified women, characteristics of women offenders, you know, such as their likelihood to have, you know, coming from impoverished backgrounds, homelessness, drug abuse, things like that. And the Joint Irish Prison Service and Probation Service Strategic Plan 2013 tried to kind of implement some of this policy. And it includes the aim of identifying and diverting women at risk of a custodial sentence through greater availability and use of diversion, community sanctions, and supports interagency cooperation. So basically, this was trying to follow international policy, and you can see how that would happen. Now, the problem with that is when judges were identifying the common problems that were common to female offenders, sometimes a judge might consider this and he might actually use it to the woman's disadvantage, where he would consider it as a risk factor, or indeed where he might consider her to be unsuitable for work in the community. For example, if she's a drug addict, he might then consider her to be like unsuitable for community service and things like that. So by identification of women's common problems and saying that they require special attention, sometimes they get attention in the wrong way, and they can be diverted towards prison because they're deemed to be. So a judge might sentence a woman to really not so much what she deserves, but what he, in his paternalistic view, might consider that she needs, and he might consider that need can only be met by prison. And this, so Ireland has been very well documented as its overuse of short prison sentences and underuse of the probation service. The figures are there. 2012 prison committal rate was 375 per 100,000. European average was only 163 per 100,000. And in 2013, the number of persons under supervision or care of probation was 143 per 100,000, and the European average was 209 per 100,000. So you can kind of see, you know, there's and my thing that's just cut out there, so I just have to go by this. Sorry about this. So community service orders have also been shown to be used quite inconsistently. So the Community Justice Act of 1983 really introduced the concept of community service orders. And what a community service order is, it's a direct alternative to prison. So a judge really would have to consider the use of a custodial sentence first. It has to be serious enough for that. And this is, in lieu of this custodial sentence, he can impose a period of 40 to 240 hours work in the community, unpaid work in the community. But a study in 1999 showed that these orders were actually being applied a bit inconsistently. Like, for example, rural areas were creating shorter orders than urban areas, and so on. Some community service orders were even being created where custodial sentence shouldn't have been considered at all. So that was a study done in 1999. Now, the community service orders of today, really, a recent study in 2015 found that this hadn't really changed that much, and the lengths of orders were varying according to district court jurisdictions as well. The offender was not always considered suitable for community service work, so this also was a reason why they didn't get community service work. And also under the international obligations against forced labour, the offender must consent before a community service order is put into place. So the other thing is community service orders for females in Ireland is actually decreasing. In 2012, the number made was 229. 2013, the number made was 204. And 2014, the number made was 191. And this is all despite policy recommendations that have been made by the 2011 Act and the strategic plan. is despite the fact that reoffending statistics after a community sentence is applied is a lot lower, and also the cost to the taxpayer, it's a lot less, costs a lot less to obviously have somebody under probation supervision than a prison sentence. Probation supervision would roughly cost in the region of €5,000 per year. Prison sentence will roughly cost about 65,000 per year. And so reinvestment would really absolutely be better put into the probation services and support in the community, as opposed to the creation of further prison spaces. And there was, the plans actually were in 2013 to build a kind of super prison to replace some of the campuses around Ireland, Thornton Hall project, and it hasn't actually developed as yet at all, but it has come to the taxpayer at a cost of 1.36 million, expected to rise a lot more. Right now it's actually still a field, and people are using community service to do agricultural projects and stuff on it, so it really is. It really should, the money should really be directed into prevention rather than prisons, if you like. The last thing I'll talk about is the use of fines. Now, fines really should be imposed by a judge where a custodial sentence is not considered at all. It's for very minor offences. The problem with fines comes in is where fine is defaulted on, and this is particularly the case. This results in a lot of females being imprisoned. Now, the Fines Payment and Recovery Act of 2014 went some way to try to minimise the effects of fine default, people ending up in prison where they shouldn't have a custodial sentence. And what it provided for was basically that the judge should consider the financial circumstances of the offender, that the fine should be able to be paid in instalments, and that the use of community sanctions as opposed to prison sentence where there is a default. This legislation really, when it filters down, we're talking about that's the policy, but when we're looking at practice then, the legislation didn't really filter down too well so far. It's only 2014 that the legislation was signed into law, but the instalment mechanism still isn't possible under the court system because the IT system in the courts needs updating and it still hasn't been done. The instalments will never be possible where a fine is for under €100, so that's just not possible. And also the other thing is attachment orders can't be made for fines to be paid where the offender is in receipt of social welfare payments. You're not allowed to attach social welfare payments. And for a lot of people really who are on social welfare payments, when they're faced with the possibility of a very, very short prison term and attaching their social welfare payments, I kind of think, and from what I've anecdotally heard, they are going to prefer a couple of days up in Mountjoy prison with their mates rather than having long-term, social welfare payments being attached. The rise of female fine defaulters committed to prison in 2007, they made up 12% of all fine defaulters. In 2014, this level has actually gone up to 26%. So actually, where a judge considers that he's being lenient and chivalrous in his decision to impose a fine as opposed to a community service order for a female, his chivalrous behaviour might actually be helping the female further up the penal scale than she should actually start off with. So finally, in conclusion, inconsistent, inefficient and ineffective use of alternatives to custody actually represent more of a denial to justice than a delay of justice, because it's not just a delay of the policy filtering down, because once a female or anyone really enters into the realm of a custodial sanction, they really have a lot of problems on their hands, because short prison sentences they provide absolutely no rehabilitation. Social reintegration problems are going to start once a woman comes out of prison, even if she is only for a week. She still has a prison record on her hands. You have family fragmentation problems. A female offender who has got children, she's going to lose her children. She's also going to, if she's in social housing, she'll probably have problems with housing at that stage. So, there's also going to be the problem with a female first-time offender who is thrown in jail for a fine default. She's going to make criminal associations, a school of criminality, if you like. Also add to this the reoffending statistics. When somebody comes out of prison as opposed to somebody who's served a community sanction, there are much higher chances of recidivism. So that's another problem. So the real problem with actually irreversible, cause irreversible harm. So I'm just going to leave with one book that I thought was very apt, and it's by Mark Johnson. And he wrote, "It's easy to use values as a mantra rather than an agenda for action." And I think this is definitely the case with veganism and custodial sentence. Thank you very much. Just a Valerie, thank you. Thank you, Sharon. That was really excellent. It really dovetails nicely with why I'm also talking about what we should not be in prison. Prosecuting, so I'm Lisa Avalos. I'm from the University of Arkansas Law School. I focus my research on international human rights, particularly with respect to gender-based and sexual violence. And this talk is about the prosecuting rapists while rapists run free, the catastrophic consequences of police failure to investigate sex crimes in the United States. So this is a talk about a human rights violation that has flown under the radar until now, and that we don't want to actually believe happens in advanced society. So your first reaction could just be denial. But what happens here is that sometimes individuals who report a rape to the police are disbelieved, and when that happens, the police fail to investigate the rape cases, and sometimes they actually charge them with false reporting. This happens in both the United States and the UK, and I can compare it work between the two countries. But what happens then as a result of this inadequate response to rape complaints, women get charged with false reporting, and in the UK, the problem is particularly severe because women have actually served prison time for false reporting, which tends to not happen so much in the US. So I'm just going to kind of flip through because I want to show you some pictures, and then I'll go through and talk about it in more detail. It's difficult to say how often this actually occurs because police forces generally do not keep track of false reports by the type of crime that was originally committed. So in most jurisdictions, we know how many false reports police report, but we don't know the underlying crime that was the false report. So I can't say today what the prevalence of this human rights violation is, but what I can do is talk about some specific cases in detail how this happens. And talk about what some of the reasons are that it happens. So essentially my argument is that the women that you see here are not actually false rape reporters. What they are women who are actually raped, who reported their crimes to the police, who were not believed by the police, and so therefore were doubly victimized by failed, ineffective, or non-existent rape investigations. And so we need to examine what went wrong in these rape investigations, and then try to address the problem. So I just wanted you to see photos and so forth. So that's kind of an overview. So a little bit of context first. First, we need to understand that rape is an extremely underreported crime. So only about 20% of all rapes are actually reported to the police. And false reports of rape are actually extremely rare. And so there are different statistics out there, but the best estimates are that roughly 2 to 3% of all rape reports are actually false. So it's a very low number, and the other thing to understand about that is that most are non-malicious, meaning that most don't identify an actual rapist. So you might have a situation where a teenager misses a curfew and says to her parents, "I'm home late tonight because I was raped on the way home." Unknown attacks, so the non-malicious in that sense. Third, studies demonstrate that police tend to pretty dramatically overestimate the number of false rape reports, so they overestimate by wide margins. So it's not uncommon when officers are surveyed about how many of the rapes that we investigate do you think are false. Officers will typically say, "Oh, I think 50 to 60% are false." So they dramatically overestimate. Or another way of looking at it is that their skepticism is out of proportion to the reality of how rare false reports actually are. And this has various reasons, which I'll just touch on here. I don't have to go into that, but there's an issue of court training, there's a lack of sensitivity to victims of sexual violence, and there are performance management pressures on police, which cause them to want to clear up cases as easily and expeditiously as possible,
you must write a specific case. So to start with an example, this is an article within the Guardian. Jane Doe, I'll call her real name was never mentioned in the press, but this is a young woman who was raped at the age of 17, fairly recently. And she said, she told the police that she thought that the rapist had gotten semen on her t-shirt. The police were supposed to send that t-shirt for forensic testing, but they never did. Instead, they formed the opinion that she was lying, and they informed her, we don't believe you, we're going to charge you with perverting the course of justice for falsely reporting rape. Her mother intervened at that point, was very angry, and filed a complaint against the police, and as a result of that complaint, the t-shirt was actually sent for testing, for DNA testing, and they found the rapist semen on the t-shirt, and they were eventually able to identify the rapist. The rapist is now serving a 5-year prison term, and Jane Doe was compensated £20,000 for what she went through. So, why does this happen? There is actually, and the reason here is that there's a big disconnect between rape investigation best practice and what the police actually do. And this disconnect occurs both in the United States and in Britain. And my research involves examining police investigations in various cases and comparing it to best practice. So when I see a case reported in the newspaper like Ellen Freitas and the other false rape report to police, I immediately start digging into what exactly happened here. What did she report? What was the precise mechanism by which the police determined that the report was false? Because that's usually where the fault line is. So in terms of best practice, and this best practice comes from two organizations that are really spearheading change in the States, and Violence Against Women International and the International Association of Chiefs of Police. Both organizations specify that if you when confronted with a rape report, the officers must thoroughly investigate each rape complaint. Second, and this is crucial in these cases, a report cannot be labeled false unless A, a full investigation has been done, B, evidence emerges and demonstrates that no crime was committed or attempted, and C, very important, that an officer must not pressure a victim to retract an allegation or use such retraction as evidence that the assault did not happen. So that's what best practice is. You've got to actually thoroughly investigate cases, have evidence that it didn't happen, and make sure you're not pressuring the victim to retract. So what I've found systematically in all of these cases is that police don't follow best practice. It's really not rocket science. They don't investigate cases, and they don't actually have evidence that no crime was committed or attempted when they charge these women. So I want to first give you a few examples out of the United States where we know in retrospect that the complainant was actually a true rape victim, and I'll contrast those with some cases where we don't know yet for sure that she was actually a rape victim. So Sarah Reedy is a young woman who was raped in 2004 while working late night at a convenience store outside of Pittsburgh, Pennsylvania, and the rapist also robbed the store when he raped Reedy. According to court documents, the officers in charge never actually investigated the case, but right from the initial report at the hospital, while Reedy was undergoing her rape kit, accused Reedy of staging the rape and robbery because she and her boyfriend needed money for a down payment on a trailer. So in this case, the officer had previous run-ins with the boyfriend and immediately suspected Reedy of staging the rape and therefore did not investigate. So while he was preparing to arrest Reedy for false reporting, he had actually told other police departments that she had reported this rape, and other police forces were continuing to investigate her case and some similar cases in the area. They actually managed to catch the rapist, who confessed to raping Reedy as well as to raping other women. That rapist is now serving a 50-year prison sentence, and Sarah Reedy sued the police, and in 2011, several years after her rape, received a $1.5 million settlement from the police. DM in Washington State is a woman who was 18 years old when she was raped in her home in August of 2008. She was living in her first apartment at the time, and she had inadvertently left a door ajar a little bit. So a man came in, tied her up with her shoelaces, and attacked her, raped her. She reported the rape to the police immediately. The police were skeptical, though, and accused her of false reporting. And in doing so, they ignored some clear evidence of her attack. So, for example, she had genital injuries that were consistent with sexual assault. Her wrists had marks around them where the rapist had tied her wrists together with her shoestrings. The shoestrings had been taken out of the shoes. The police could see that. And then another thing was that the rapist came in a sliding glass door to her property, and it was surrounded by a fence, and the fence was covered with a lot of debris. But there was a spot around the fence where the rapist had come over the fence, and you could see that the debris had brushed off where somebody had come over the fence. So the police noted all these details in their reports, but instead of focusing on the evidence of the rape, they paid attention to the fact that they received 1 or 2 anonymous phone calls from people saying, oh, we know DM and we don't really believe she was attacked. We think she's a liar. So the police put a lot of weight on those phone calls, and they overlooked and ignored the concrete evidence that she had actually been attacked. So they pressured her, they brought her into the station, they pressured her to retract her rape allegations without a lawyer present. And when she did so, they charged her with false reporting. So meanwhile, while all this was going on, DM's rapist, Mark O'Leary, carried out another rape in Washington State, and then he went to Colorado and he raped 5 more women. While he was in Colorado, some detectives got on his case and really started investigating that series of rapes in Colorado, and they managed to track down Mark O'Leary, and they linked him to DM's rape through evidence on his mobile phone because he was in the habit of taking pictures of all of his victims. So they called the police in Washington State and said, hey, we caught that attacker in this DM case. So Mark O'Leary was convicted of rape. He's now serving 327 years in prison. And DM sued the police, and just recently, several years now, I think 6 or 7 years since her rape, she settled with the police for $150,000. So those are a couple examples of how some of these cases have played out where there's no investigation. Patty, I'll just touch on very briefly, was a similar case, raped in her home, was charged with false reporting because the police did not believe her and they did not fully investigate her case. What vindicated Patty was that she was very, very vigorous. Well, first of all, she also was taken into the station, pressured and coerced into retracting, and then charged with false reporting, same as DM. So she went through the whole process, but once she left the station, really started to try to campaign to clear her name. She was successful in, one of the issues that happened was that the police had taken all of the bed sheets and the blankets off of her bed. They were supposed to send them for DNA testing, but like in DM's case, there were some materials that were never tested. So eventually, she forced a crime lab to test the sheets on her bed, and that produced the rapist's DNA, and the rapist was eventually linked to Patty's rape, and she was vindicated, and her rapist is now serving a 50-year prison sentence as well. So those are some examples of actual victims, genuine victims who are prosecuted for false reporting. So one of the questions, Laura McLeod is just another similar case. I don't have time to go into hers, but this was fairly recent. And the fact that the police didn't believe her rape case meant that ultimately her nephew, her 2-year-old nephew, was killed by his father. The father of her nephew is the man who raped her. And he was able to gain custody of his son or access to his son through visitation because he was encouraging the police to think, Laura and her sister, they're just liars, don't believe them. He ended up killing his son, and that was a fairly recent case. So then, in some of the other cases, then the question that I ask in my research is how many other victims are also true, genuine victims who are being prosecuted for false reporting, who have not been lucky enough to have their names cleared yet. And so what I found as I look into some of these other cases is that they're plagued by the same investigatory failures as the cases where we know for a fact, in retrospect, that the woman was actually a victim. And so I wanted to just touch on Gail Sherwood and a couple other women as I have time. Gail Sherwood is a woman I've worked closely with, and I've spent many hours interviewing her and going through her court documents. Gail Sherwood reported 2 rapes to the police in 2008 here in the UK in Gloucestershire. And on both occasions, she was found in remote locations with her hands tied like this, tightly together, and also tied to a fence. And she was accused by the police of staging these rapes and tying herself up like this. When she was found on those occasions, she also had genital injuries that were consistent with sexual assault, and the police tried to explain those away by saying that they were self-inflicted. On the second occasion, she was gagged so tightly that the first responding officer rushed to cut the gag off because he was so worried that Gail was not able to breathe. She was highly, highly distressed on both of these occasions. Now, Gail had claimed to be the victim of a long-term stalker, and so she alleges that the same man has carried out stalking and rape attempts against her over a long period of time, going back even farther, but starting most recently in 2007 and continuing on to the present. So despite the very strong evidence that she had actually been raped, police charged her with false reporting on the basis of footage from a hidden CCTV camera that they had at her house. So they had gotten permission to do covert surveillance, and they had a camera on her driveway. And they focused on a little piece of footage from the night of the second rape. And on the night of the second rape, what Gail Sherwood said happened to her is that she heard A noise in her house. She came downstairs to investigate, was immediately hit over the head with a hard object. She lost consciousness. She remembers falling to the ground, losing consciousness, and then waking up 20 minutes later as a passenger in her own car. And then the rapist, the assailant, took her to a remote area, tied her up, and raped her. That's what she remembers. The police looked at the video footage and said, well, you know, what we're seeing on this footage is that at 1:30 in the morning, one person comes out, gets in your car, and drives away. The quality of the footage is really terrible because it is designed, it's not a camera designed for low light conditions. It was taken in the middle of the night. It's impossible to tell who that individual is. You can't even tell if the person is male or female. A defense facial recognition expert hired by the defense said on a scale of 0 to 8, where 8 is a very high quality image, this image is between a 1 and a 2. And for this defense expert to be able to make a clear match to a specific person, he would need to have the image quality at least about a 6 on a scale of 0 to 8. So it gives you a sense of how poor this image was. The police had no trouble getting on the stand and testifying that in their view, that person was Gail, and the fact that that car drove away, that she drove the car away herself, means that she lied about both rapes. And on one hand, this isn't even logical because footage from June 1st can't possibly disprove a rape that happened 6 weeks earlier, the first rape. And even if she did drive the car away that night, that's one inconsistency in a story. Because the victims are traumatized, there's often multiple inconsistencies, and that doesn't mean that they weren't raped. But that image can't really discount the reporter's rape, and yet that was what was used to convict her. What's more interesting, and she was convicted actually of perverting the course of justice, but what's even more interesting about that video footage is that the same night, approximately an hour earlier, before the car drives away, that video camera, the same video camera the police had, actually catches the image of a man walking on Gail's property within 15 feet of her house, just past the car there. And this man meets the description of the stalker. You see him from the waist up, as she described it, a 6 foot tall guy with very broad shoulders, and that's who is in this image. And so the police actually had evidence that there was a real stalker on her property who had no other reason to be there, and yet they ignored that in their investigation and they focused on prosecuting her. So that's what happened to Gail. Layla, I'll just discuss very briefly. She reported a rape in the north of England, and as in Patty's case, she was raped by a stranger. She walked home. Initially, it looked like the police were investigating the rape, but then they became skeptical of her. The most interesting piece of evidence in Layla's case was that they did a rape kit, and Layla is, as you can see, this is her normal hair color. She's brown haired. They found a blonde pubic hair when they did the rape kit, and that pubic hair was DNA tested to belong to a male. And Layla didn't have any sexual partners that meted that description. So they actually had some physical DNA evidence from the rapist, but they ignored that and they still focused on prosecuting Layla. Both Layla and Gail served prison time in 2010. Layla actually gave birth to a baby in prison, and both of them are now trying to clear their names. Rhiannon Brooker and Eleanor DeFreitas, I don't have time to go into detail right now, but the one detail I want to mention about these two cases, they're very striking in the sense that these cases are more recent cases than Brooker and Ibrahim, and the police actually did a fairly decent job investigating the cases. The police actually believed the victims, and the decision to prosecute Brooker and Ibrahim was taken by the prosecutor, who then tried to get the police to cooperate with the prosecution decision. In both cases, the police refused to cooperate because they believed the victims, which is a sign that something is amiss when the police won't cooperate with prosecutors. So these cases, and these are just some headlines from my own university where we've had the same issue with 2 undergraduates in the last 5 years being charged with false reporting. And again, I've looked at both reports, and they both look like failed police investigations to me. So these practices, I'm arguing, are a human rights violation. There's a key court decision that came out in 2014 here by the Court of Appeal in the UK, which found that failing to investigate rape violates Article 3 of the British Human Rights Act and the European Convention on Human Rights. Article 3 is the right to be free from torture, including inhuman or degrading treatment. And this decision that came out in 2014 involved 2 of the victims of John Warboys, who, as many of you know, was a serial rapist, black cab driver who raped about 90 women before he was caught. In that case, police did not believe Warboys' victims because they thought that no black cab driver would risk his license in order to rape women. But the police were wrong, and their incorrect belief on that got in the way of them carrying out a full investigation. So I'm arguing that we're seeing the same Article 3 failures in these cases, but they're actually magnified because in addition to not having their cases fully investigated, these women are in a situation where the police are going one step further and actually prosecuting the women for false reporting. And so there's additional human rights violations going on here as well. The Article 14, right to non-discrimination on the basis of gender, is in play. The right to a fair trial is also in play because, you know, for one thing, you shouldn't even be on trial when you're a victim. But for another thing, how can you get a fair trial when the police haven't fully invested your case, so the jury don't have a full grasp on what's going on? And then the Article 13 right to an effective remedy is also implicated because we're in a situation where rape victims essentially don't have an effective remedy when they go to the police and they report a rape. So what needs to happen then? Just some recommendations here. So the problem here in these cases is that clearly there's a problem in that cases are not fully being investigated. But the underlying problem, in addition to that, is that there are no safeguards in place to ensure that genuine victims are not being charged with false reporting. And so what we need here is the priority is to implement safeguards to ensure that victims are not being treated in this way and charged with false reporting. And so my recommendations go along those lines. And again, they're tied to some of the best practice we've seen coming out of End Violence Against Women International and the International Association of Chiefs of Police. And so the first recommendation is that the best practice guidelines that I referred to earlier really must be mandatory. And so right now, they're discretionary. Similar best practice guidelines are used in the Metropolitan Police and other forces across the UK. But the problem is we don't have any mechanism in place to make sure that police are following them or to obligate police to follow them. We don't have any mechanism in place to ensure or to make police prove that they've actually fully invested in a case before they charge a victim. And so what we need to do is to make those guidelines mandatory. In American jurisdictions where they actually have been used, there's demonstrated, it has been demonstrated that they're more effective than not using them. So the issue there with those is to ensure police accountability. The second proposal, external review of police and prosecutorial decision making, is another idea that's been growing in popularity in the States and that has demonstrated results. And it involves having outside agencies that engage in the support of rape victims, review police case files, review police decision making, and make recommendations about further steps police can take to fully investigate cases. And so essentially, it's making the investigation process transparent and it's holding police accountable. And then the third issue is that, you know, in my view, and I know that to some people in the UK this is controversial, but the fact is, I think it's really important to eliminate this whole policy that the CPS has of charging rape complainants with false reporting. This issue is kind of like the death penalty in the US. You know, you guys are more advanced than us in that sense. You don't believe in the death penalty. We have the death penalty, and the biggest reason that people argue against the death penalty is the racial dynamics involved and the fact that we are putting to death innocent people who were wrongly convicted. And these false reporting prosecutions are the same way. We have no idea now how many of these women are actually victims that are now being victimized in an additional way because they're actually actual victims. We also know that the policy has a chilling effect on victims who are then afraid to come forward because they don't want to be treated in the same way. And I've seen some very clear evidence of that. Just the last thought to leave you with that. For every 100 rape reports, the situation in both the US and UK right now is that for every 100 reports, about 3 rapists are convicted, 2 or 3 other reports maybe are false, and that means that you have about 94 perpetrators who are getting away with rape. And so rather than concentrate scarce prosecutorial rapists or resources on prosecuting supposed false reporters, we ought to be trying to put away those 94 rapists that actually aren't being caught. And so that's where our priorities ought to be. And there's my contact info if you'd like to chat any more about this. So thank you very much.
Thank you to Lisa for her paper. We now have about 5 or 10 minutes for questions and comments until we can go over slightly. So does anyone have any questions or comments they'd like to address to any of the speakers that we've heard from this afternoon? Any comments?
This is for Sharon. You spoke about the fines, the fines. One of the problems we have in the United States is that in addition to fines, which may not always be very high, there are then these hidden court fees that people are required to pay, which can be exponentially higher than the fine that's actually imposed. Is that a problem that exists in Ireland, where there are these sort of hidden costs of the court system that are imposed on people?
Yeah, absolutely. So debtors, especially debtors, it's actually a separate category really, but the number of female debtors being committed to prison has also increased. Yeah, and that really is that does. There's a whole different issue really, and it's really about how the courts propose to deal with the issue of debtors who cannot get out of debt, and there's a whole system that needs to be looked at really as to what do they do really when somebody can't get out of debt, you know, because they're already in a very vulnerable financial situation, and you know there is the attachment of earnings where they are earning, but often where there's an attachment of earnings threat, they will cease their employment, and they will go on to social welfare where their earnings cannot be attached under current legislation. So yeah, it is a big problem.
Any other comments or questions?
It's for Choky. I'm wondering if you've looked at the, excuse me, the plea bargaining system in Taiwan. It's a civil law system, but they implemented an adversarial system for criminal courts, and actually started a plea bargaining system, I think about 10 years ago. I don't know too much beyond that, but that'd be something.
Thank you. I will look at the Taiwan's labor again to have more resources with labor gain experience.
Any other comments?
Yeah, I have a question for Choky as well. In the beginning of your talk, you talked about the need for efficiency, and you had graphs about increase in the trials cases of trial. And I'm just wondering if you know what factors are leading to more trials, if it's an increase in criminalization, or if it's I don't know, greater prosecution of crimes in existence. Because if it's increased criminalization, then there may be an argument not to increase was criminalization of cases that should be legalized.
Yeah, thank you. You're right. Some of Indonesian law consists of the like criminal sanctions that will be restricted to any citizens. So that's one of the problems regarding the increased levels of Indonesian courts. Yeah, that's good.
Thanks, Matt. My question is actually for Lisa, and it's just in relation to the relationship which exists, perhaps not the relationship, but in your own, I suppose, the field studies which you've actually carried out, is there a direct link between the failure of the police to investigate the actual crime and the socio-economic profile of the victim, or do the victims tend to come from a particularized background, or have they similar characteristics which would lead the police to properly not investigate the crime?
Okay, yeah. So I think to give a really good answer, you have to have a very large pool of data, which you don't have. Based on the cases I've examined closely, the characteristics that are most obvious is they tend to be very young women, and they tend to be women who are vulnerable in some way. So they tend to be younger. Sometimes it does seem like socioeconomic status is a factor as well. And the other thing is that if they're not younger, then sometimes they have some kind of disability. So, for example, the Patty case from Madison, Wisconsin, she was legally blind. She had macular degeneration, and so she had that disability. Gail Sherwood can only also has a condition where she can only see out of one eye and not the other. And so there's either an age issue or there's some kind of disability involved. And those are precisely the same kinds of characteristics that rapists use when they're choosing, who to victimize, because they also are looking for more vulnerable people. So it's that same pattern of vulnerabilities. Yeah.
So that's like 1 or 2 more questions.
Just to follow up to that, I was quite struck by the statistics. I think you said that about 2 to 3 rape reports are false reports.
Right.
But the police believe the number is 50 to 60%.
Right.
It's obviously a huge disparity.
Right.
And then one of the examples you used was of the police doubting the report of someone who had contact with the police. And often, as we know, the people of lower socioeconomic classes are more likely to have contact with the police.
Right.
Would you say that it's generally those sorts of grounds that they choose to disbelieve because they're familiar with the victim? They think, oh, I'm familiar with this person's background. I've dealt with it before. Or is it this? It just strikes me that it's just a callousness then almost that all of these women are lying to, and that you're right. It is hard to accept, and that's the part that I struggle with is trying to rationalize how the police could just say, "Oh no, you're lying to me." That there has to be, in my mind, I recognize there isn't always, but in my mind, it feels like there has to be more because I hate the idea of living in a society where the police would say, "Oh, well, she's a woman, she's lying." So,
that's part of the message. I think there's a couple other things that explain it. I do think that the more education somebody has, the more articulate they are, the harder it is for the police to dispense with that person by saying you're lying to me. Because if you have those kinds of characteristics, you're going to come back and you're going to challenge them, and you're going to be like, what the hell are you talking about? I was great. And if you have that ability, they can't dispense your report that way. So what I've seen them do this. It's particularly common among very young women, sometimes of very low socioeconomic status. Sarah Reedy was living out of a car with her boyfriend, but I've seen it on my own college campus where it's 18 and 19-year-old, and I think it's significant. These are freshmen and sophomores in college. They're the most vulnerable people in the community that are being treated in this way. And so I do think that's a factor. I think the other thing that I would just slip in here is that the performance management pressures on the police, I think, also go a long way to explain this. So you can be, and I've had officers tell me, you're in a situation where you're only allowed to have a certain number of crimes in any given category in a month, or it looks like crimes are going up instead of down. So that puts a lot of pressure on them to try to talk people out of the crimes that they've reported. And so that's partly why this whole issue of police pressuring victims to retract allegations is something that's so prevalent, because it's self-serving for them as well. So, yeah.
I think we probably have just about run out of time for questions, but thank you once again to everybody that asked questions. And thank you once again to our 3 speakers, Choky, Sharon, and soapbox sessions taking place in here next, is that right?
That's right, yeah.
So you can stay here.